Welcome to Part 4, the hearing. It's been a long process getting to this point, but you're finally ready to start preparing for your hearing before an administrative law judge. In this video, we'll be addressing several housekeeping issues that will prepare you for your hearing and help you avoid simple mistakes. We'll also help you avoid mistakes in your testimony and give you practical tips on how to effectively answer questions before your judge. Let's begin by going over several items to make sure you're completely prepared for your hearing. Do you know where the hearing office is located? If you don't already know the exact location of the Social Security hearing office, we recommend you choose a day prior to your hearing date and visit the office. Knowing where you're going and how to get there will remove a lot of unnecessary stress. Medications. A common mistake people make on the day of their hearing is they either don't take enough of their medication as prescribed or they take more medication than is prescribed. Please don't do this. If you're in a lot of pain, don't over-medicate the day of the hearing. The reasoning is simple. By hiding your pain from the judge, you'll only hurt your case. Remember, you want the judge to see your pain or other impairments as you experience them on a normal day. Also, make sure you bring a list of your current medications. No doubt your judge will ask you who prescribed the medicine, what it's for, how much and how often you take it, and what side effects you experience. Next, don't be late to your hearing. Arrive 30 to 60 minutes early, allowing yourself time in case you have any unexpected delays. The judge has the power to approve or deny your benefits, so please be on time and give the judge every opportunity to approve your claim. Guard your words and actions. Remember, Social Security hearings must be treated seriously. You will most likely be nervous, but while you're in the hearing office, don't talk about your case or make jokes. There will be Social Security employees throughout the building, and the last thing you want is to say something and have it misinterpreted by a Social Security employee who then goes and shares it with your judge. Assistive Devices. On the day of your hearing, you should bring any assistive devices that you normally use. This includes your cane, walker, crutches, wrist braces, back brace, neck brace, etc. It's difficult to convince the judge that you need one of these devices if you don't bother to bring it to your hearing and use it. If you're claiming you need a cane to walk and you walk with your cane slung on your shoulder or tucked under your arm, the judge will question your credibility. How to dress. A common concern people have is not knowing what to wear to their hearing. Social Security hearings are less formal than what you might see on TV. However, the way you dress should always reflect respect for the courtroom. Avoid wearing a pair of shorts, a tank top, or a hat to your hearing. On the other hand, you also don't want to get all dressed up in your best suit. A judge might then look at you and think you're ready to go back to work. Just dress comfortably, like you would on a normal day. You'll want to be comfortable, but remember, you are in court. Now let's go over what to do when you first arrive. When you enter the building, you'll have to pass a security guard who will check you and your bags to make sure you don't have anything illegal. You will then walk up to the counter and show the employee a picture ID. Once you're checked in, you'll have a seat in the waiting room and wait until your hearing is ready to begin. Once your name is called, you'll be escorted to your Social Security hearing room. Unlike most courtrooms you see on TV, Social Security hearings are much less formal, and the informal setting was designed to help you feel relaxed and comfortable when you testify. If you live too far from a hearing office, a visiting judge may come to your city, and your hearing will be held in a community building, usually a hotel conference room. Let's go over exactly who will be at your hearing. The most important person besides you at the hearing is the judge. The judge will run the hearing and ultimately make the decision on your claim. The judge will also usually have a hearing assistant who helps with the recording device. Next, there will be up to 2 expert witnesses. The first is a medical expert who's there to help the judge understand your medical records and any limitations you may have. The second expert witness is called a vocational expert, who's there to help the judge understand how your medical conditions and limitations affect your ability to work a full-time job. As a general rule, expert witnesses won't ask you questions other than to clarify something they don't understand, such as the date of a surgery or specific job duties performed in the past. The third type of witness that may be present at your hearing is your own witness. If your doctor or therapist is willing to testify on your behalf, you should make every effort to encourage their attendance. The approval rating dramatically improves when a treating doctor testifies. Short of a medical provider, you will want a witness that has first-hand knowledge of your disability and limitations. This can be a friend, relative, or care provider. The purpose of your witness is not to repeat everything you say, but instead to offer new and additional information for your judge to consider. An example of this may be if a person suffers from a seizure disorder and can't describe to the judge what happens during the seizures. Naturally, having a witness testify as to how long the seizures last, what happens during the seizures, and how long the recovery takes are all important. If you bring your own witness to testify at the hearing, you'll need to let the judge know at the beginning of the hearing so they can make time for your witnesses to testify. So to recap, you could have as few as 3 people in your hearing: the judge's assistant, and you, or as many as 6 people, with the additional 3 being the medical expert, vocational expert, and a witness that you bring. No doubt, the thought of going before a judge and having a hearing to determine if you're disabled can be very stressful. But thankfully, the hearing itself is really pretty simple. The hearing procedure, or in other words, the order things will happen. Here's how the hearing will begin. The judge will introduce themselves, along with the hearing assistant and the vocational and/or medical expert witnesses. The judge will then read a very brief statement setting out the issues to be heard, and then will ask you a few basic housekeeping questions regarding how prepared you are for the hearing. For example, the judge may ask you whether you've submitted all of your relevant medical records. The judge may ask whether you have any objections to the expert witnesses. It is usually not a good idea to challenge the qualifications of an expert witness, unless the judge's expert isn't qualified to testify on your conditions. Next, the judge will have you swear an oath to tell the truth, and then will ask you questions related directly to your disability. You can find a list of typical questions a judge may ask by going to the Resources section in the main menu of this site. Although the judge won't ask all the questions on this list, you'll get a feel for what types of questions you can expect. Once the judge is finished asking you questions, he'll turn the questioning to the medical expert, who will testify as to your impairments and limitations. The medical expert's opinion is based exclusively on the medical records. Therefore, anything you say in your hearing likely will not affect the expert's testimony. Following the medical expert's testimony, the judge will turn to the vocational expert, who will describe your past jobs and testify about your ability to perform those jobs. The judge will then offer the vocational expert some hypothetical questions to determine whether a person with your limitations would be able to perform full-time work on a competitive basis. Once the testimony of both experts has concluded, the judge will close your hearing and you'll be free to leave. Although we have described the role of both experts, it's not uncommon for a judge to have only one or even no experts at the hearing. If there are no experts, your hearing will be finished when the judge is done asking you questions. Now that you're prepared for what to expect on the day of your hearing, let's move on to preparing your testimony. In the next video titled, How to Testify, we'll show you what areas of testimony the judge will require, and we'll share tips and examples on how to present your answers in the best way possible.